Last case on the docket this morning is Linge versus DeFilippo. Did you need to take it first?
Yeah, I'm fine. Yep, thank you.
And you're on it? You take
Right.
it. Morning, may I proceed?
Good morning, Your Honors. May it please the Court, I'm Jake Caney here on behalf of the appellants, Joey and Joe Linge. Although sometimes I pronounce it Ling. I would like to reserve 5 minutes if possible.
Okay.
We are here on the Linge's appeal of the lower court's denial of summary judgment on and dismissal of counts 4 and 5 of the Appellee's second amended complaint.
Mr. Caney, I just want to make sure you're not taking any issue with the sufficiency of the evidence that was presented at trial.
Well, not for purposes of this appeal. There was things that I take issue with, but for purposes of the undisputed material facts in the summary judgment record relative to counts 4 and 5, no. In fact, none of those facts were controverted at trial, some of which were actually agreed to or stipulated to in the admitted facts that the trial judge read to the jury at the close of the evidence. But the material facts, the facts that are material to all, let me back up real quick. Counts 4 and 5 of the second amended complaint each alleged various, it's kind of a throw in everything but the kitchen sink complaint, each alleged various alleged breach of fiduciary duty claims. Count 4, I believe, was based on common law, and count 5 was based on the statute in Chapter 608. These are LLCs, the two companies that we're here about.
As to the summary judgment issue, is the basis for your claim that the trial court erred in granting the motion for summary judgment in your favor that there are material issues of fact to be resolved?
I don't understand the question, I'm sorry.
What was the basis for the argument that the court should have disposed of the breach of fiduciary duty claim as on counts 4 and 5 by granting the motion for summary judgment? What is the basis for that claim?
Okay, yes. The material facts as to each of the fiduciary duty claims that were alleged in counts 4 and 5 were undisputed, were not disputed at the trial court level. We filed a plethora of summary judgment evidence. It's all outlined in the motion for summary judgment. The other side filed nothing and pointed to nothing to raise any issue as to...
There were no issues of material fact to be resolved, and as a matter of law, the trial court should have granted summary judgment in your favor. Is that right?
That is our position in the general, yes.
The reality of that, of course, is that this went to trial. The jury heard all the evidence, and they disagreed with that. And they found that as to the facts, that the facts were against you, and the trial court apparently instructed them as to the law, and they found that the law was against you as well. So how do we deal with that?
Well, I would point to the I-90s case that I cited on brief that says that it is proper for an appellate court to reverse the denial of a motion for summary judgment when, as here, the undisputed material facts in the summary judgment record were not controverted at trial. And as I started to explain a moment ago, there was a variety of different fiduciary duty claims alleged in each count 4 and 5. Only one went to the jury.
But the jury disagreed with your rendition of the facts or your interpretation of the facts, didn't they?
No, it did not, Your Honor. No, it absolutely did not. There were no interrogatories to the jury. The verdict form was simply well, actually, it was two other claims
Well, I'm
went to...
assuming if you had a jury trial, that all the issues were presented to the jury, isn't that correct? The trial court didn't leave anything out. I mean, I don't see where you're contesting any of that in this particular case.
Your Honor, the facts relative to the appropriation of corporate opportunity, or as they phrased it, taking the business for themselves claim, which is the only one in 4 and 5 that actually went to the jury. The rest of them did not. Now, we do contend that the summary judgment should have been entered on the rest of those claims, regardless of whether they went to jury or not, and that's all on brief. But focusing now on what you appear to be focusing on, which is the...
I'm not sure I'm following you. Are you saying that the jury did not consider the issues as to counts 4 and 5 that you are saying were incorporated into the motion for summary judgment? Did they hear those issues or not?
I'm saying that there is exactly zero evidence at trial, so I'm pointing back to the I-90s case, uncontroverted at trial. There was zero evidence to refute the facts material to the appropriation of likeness claims, which generally were, there was no competition or interference prior to dissolution. I'm sorry, go ahead.
Why aren't you arguing then that there's no substantial competent evidence to support the verdict in the case, rather than the summary judgment should have been granted?
Because we did not want to appeal the jury verdict. We'd rather keep it clean on the summary judgment record coupled with the I-90s case. And the record's borne out. I mean, on brief, I go into greater detail than I'm here, but...
There are cases that suggest that when summary judgment, a motion for summary judgment is denied, and it goes to the trier of fact, and the trier of fact renders a verdict or a judgment that's contrary to the movant's position in the motion for summary judgment, it's very rare that there would be an argument that would actually be successful, saying that the motion for summary judgment should have been granted and the trial court erred in denying it. I mean, where does this come into the rare exceptions to that? Or shouldn't there be a general rule that basically says if the trial court denies a motion for summary judgment and the jury hears all the evidence and testimony and they render a verdict that's contrary to your position in the motion, that's it?
Your Honor, that is a general rule, and the exception I've cited in the initial brief and also discussed in the reply brief, page 2 I'm looking at, where it says, I-90s held that an order denying summary judgment is appealable following a jury trial when, as here, the material facts are not in dispute and the denial of the summary judgment is based on the resolution of a purely legal question. Now, we've talked about the facts on summary judgment relative to the appropriation of likeness claims not being uncontroverted at trial, and that's reflected in the record. But as to the second part of that prong, the law, we relied on a variety of cases, but as the lower court said, our strongest case was the Cohen versus Hadaway case that we cited on brief and also in the summary judgment below and argued below.
Don't you think that it would be an odd opinion, to say the least, for us to say that, well, there's a motion for summary judgment saying there are issues of fact, or there are no issues of fact to be resolved, and as a matter of law, the case should be decided in our favor, at least these issues, and then it goes to the jury and they render a verdict that's just opposite to that?
I don't think that's odd. I don't think I-90s is odd. I don't think my appeal is odd, Your Honor, with all due respect.
If we were to write an opinion like that, I mean, I'm trying to work that out in my mind, how we would rationalize that.
Well, you could do it the way the Fourth did at 93 Southern 3rd 431 in the case cited on brief. And as to the legal issue, Your Honor, the facts were undisputed at summary judgment, and also there was exactly zero evidence at trial to controvert those undisputed material facts, that the Linges did not. First of all, there was no exclusive duties as to these companies anyway. That was expressed in the operating agreements, which the jury returned a verdict in our favor on those two counts. But there was the fact that Linges used the new companies which did not compete prior or interfere prior to dissolution pursuant to Chapter 608 in the operating agreements. The fact that the Linges used these new companies to engage in a similar business after dissolution of the Daytona Helmets companies did not appropriate the dissolved company's opportunities, nor was it otherwise actionable under Florida law. And we cite, again, the Cohen versus Hadaway case from this court, which talks about how, basically what this case comes down to, in essence, let me just cut to the chase. What their argument is it's unlawful in Florida to dissolve a profitable company. My clients didn't compete with the LLCs prior to, they did not violate Cohen versus Hadaway. They dissolved pursuant to the statutes and the operating agreements. There was no disputed issue as to, actually, they tried to dispute some issues. They argued, but they didn't point to any evidence as to whether the dissolution was fair. Those facts wound up being admitted. They weren't controverted. There was no issue made, a genuine issue of dispute as to summary judgment. They weren't controverted at trial. In fact, not only was that not controverted at trial, that most of that stuff was read to the jury as admitted fact.
The premise of the testimony presented by the opposing side that, well, the dissolution occurred to take out his interest in the company so that they could have their own company without his involvement and sharing the profits. Wasn't that the whole premise of their argument and their evidence that they presented?
Basically, what they're saying is you can't never dissolve and liquidate a profitable company in Florida.
I thought their argument was based on these facts and circumstances and the testimony that was presented, that's what they tried to do, dissolve the company to dissolve his interest in the company so that the other two could compete in their own company without his involvement.
I'm not sure I understand that.
Well, wasn't it, I mean, I think it's rather simple. Their position was that they planned it all along. They took trips overseas. They fabricated some type of excuse as far as the cost of the materials, which would make the company less profitable, to the point where they were considering dissolving the company as they couldn't continue going on with the company. They planned it ahead of time. There was an allegation that when they went overseas, they actually locked up the business and they refused to allow Mr. DeFilippo to have access to the business. There was a key that didn't work when they went overseas. You were saying that they, in fact, your client was saying you invited Mr. DeFilippo to go overseas. Mr. DeFilippo disputed that. So their position was it was planned on your client's part, and I believe that's probably why the judge took a pass and said, you know what, I think the jury should sort this out, and the jury should eyeball the parties involved and see who the jury believes. Isn't that in fact what happened here? Their position was it was planned from the beginning. He was an outsider. It was 3 shareholders, and he was the only non-family member, and they intended to cut him out from the very beginning.
There's a lot of levels to that question. That might have been their position, but that's not what...
That's an issue of material fact for the jury to sort out all of the different motives behind the business relationship and the fact that there was no interruption of the business to the Linge
Linges or Linges, whichever.
Because the business continued after Mr. DeFilippo was then excused from the partnership.
Your Honor, there's different parts to that question, but on the fabricating expenses, they did not, as I argued below and on brief, create a genuine issue of disputed fact for purposes of summary judgment below on that. And in fact...
Did they continue with the business with the same supplier after, hold on, let me finish my question. After the business with Mr. DeFilippo was dissolved, which he objected to, the Linges continued that business with the same supplier that they made the claim to Mr. DeFilippo that they were going to have to terminate because the cost of materials was increasing.
Back to the fabricated debt real quick, Your Honor.
Did they continue with the business?
No, it was a different business, but it wouldn't matter under Florida law. They're allowed to dissolve a company as long as they don't violate the prohibition set forth in COA, and the record was undisputed on that at summary judgment.
What was the reason why they dissolved the company then?
Well, for purposes of the Florida law and undisputed record, it doesn't matter. The reason, though, was that the prices went up first, but then they lost their supplier. The Indians, the Chandaks, they wanted to do it their own way. So it is a very similar, although technically different business model. They're marketing instead of obtaining on credit, which was an admitted fact, as I was trying to get out. There wasn't a fabricated expense. That was read to the jury as an admitted fact. Not only did they not create a disputed issue, material fact on that at summary judgment, they admitted that. That was an admitted fact to the jury. So that didn't happen. But whether it was the same business model or not doesn't change the fact that Cohen versus Hathaway was not violated. The dissolution was done pursuant to the statutes and the operating agreement, and he got actually more than his 1/3 share of the liquidation proceeds. And in fact, not only was that not disputed at trial, but there was no genuine dispute as to that at summary judgment, which is what we're here on now. So it was a different business model, but that doesn't matter. That's not a material fact. That is an immaterial fact.
So what are we to make of this jury verdict, that it was just
Nothing, Your Honor. We didn't appeal
verdict
that.
by a jury that was just out of control, or what are we supposed to make of it?
No, I don't think you need to do any of that, Your Honor. I think what you need to do is decide whether I am correct that the material facts on summary judgment as to that issue, and also all the others, it was only the appropriation of likeness that went to jury, and that's evidenced, by the way, by the verdict form. But if you need a record cite, I can give you. But what you need to decide is whether, like in I-90s, the summary judgment record was undisputed on the material facts as to all the claims, but especially the one we're talking about, and whether on those undisputed facts, my clients were entitled to judgment as a matter of law, like the fourth said in I-90s. And then finally, the third part would be, as the court said, the fourth said, would be to look, at the trial record to see if any of those material facts were controverted at trial. Now, I've told you they weren't. If you look at their brief, none of the times they...
Well, what then does the jury verdict tell us in this case? I mean, about what happened here? Doesn't it tell us that basically they thought that this was a scheme employed by your clients to get rid of Mr. DeFilippo and his interest in the company, and that they went about it in an ordered manner to do that?
I honestly can't tell you what they thought, but what I'm guessing would be that they disagree with this court's opinion in Cohen versus Hathaway. That's a legal question, not a jury question.
So there's no issue below, though, as to whether or not your clients owed fiduciary duties to Mr. DeFilippo. So as a matter of law, there's no question that the fiduciary duties existed. So this isn't a case where, at summary judgment, the trial court got it wrong because, as a matter of law, there was no fiduciary duty owed. The only question, your argument is that...
We're saying there's a breach.
Right. Okay.
We're saying there could have been a question. We didn't raise that below, so I don't want to waste time talking about it, but that wasn't part of our case.
But just in terms of understanding your argument that the trial court should have granted summary judgment, your argument is not there should have been a grant of summary judgment because, as a matter of law, there was no fiduciary duty owed between the parties. Your argument is that there were fiduciary duties owed as a matter of law, but based upon an undisputed set of facts, there was no breach.
Yep.
Okay.
Yeah, no, we did not raise, you're correct. The short answer is yes.
Thank you.
Am I down to under 3.5 minutes?
Yes, you've got about 3.5 minutes. You want to reserve it?
I do, unless there's a pending question at this moment. I would like to reserve it then. Thank you, Your Honor.
Okay.
Good morning, Your Honors. May it please the Court. My name is Jared DePaul, and I represent the appellee, Robert DeFilippo. The Linges appealed the denial of the summary judgment motion as to counts 4 and 5. Their argument being that there's no material facts in dispute. They're entitled to judgment as a matter of law. As the Court pointed out, there was an issue of material fact to be put to the jury, and that was whether or not the Linges took the business of Daytona Helmets to exclude Robert DeFilippo from any further participation in it. Mr. DeFilippo was a 1/3 owner before the dissolution of these entities, and then after the dissolution of the entities, he owned nothing, and the Linges continued on the same line of business, using the same supplier, to the same customers, the same location, same employees, same website, same phone number, same trade name, same logos, same everything. The only difference being that DeFilippo is no longer a member of the business. In his motion for summary judgment, the Linges basically cherry-picked some of the allegations out of the second amended complaint and attacked those, saying there's no evidence of any of that. They they argue there's no evidence that they wrongfully treated company assets as their own. There's no evidence that there was unauthorized compensation and salaries and bonuses paid to them. No evidence that they used company funds for personal obligations and expenses, and no evidence that they failed to account regarding business income and expenses. None of that has anything to do with the basis of liability that we pled and ultimately prevailed upon before the jury, which is that the Linges took the business at Daytona Helmets for themselves to the exclusion of Mr. DeFilippo. Their motion for summary judgment completely ignores that allegation, and it's their burden as the summary judgment movements to negate any basis of liability. As the non-movements, we don't have to put on any evidence. We don't have to prove our case at the summary judgment hearing. If they fail to carry their burden, that's it. It should be denied. And that's what happened. There's no transcript of the hearing, but at the hearing, I mean, there's no transcript of it, but obviously they didn't argue that the point that there's no liability or no facts that they took the business to the exclusion of DeFilippo in their motion for summary judgment. And what they do is they try to recast that allegation into a usurpation of corporate opportunity claim. This isn't a usurpation of corporate opportunity claim, and there's a case that specifically distinguishes this type of activity that the Linges did by dissolving the entities and taking the business and continuing it with them for themselves from a usurpation of corporate opportunity. This wasn't a deal that the Daytona Helmets business could have taken on. It was their business. They took the whole business, not an opportunity. So
At the time of the trial, was the jury presented with a set of facts that addressed improper payment of salaries or use of the corporate funds for personal expenses, or was the trial limited solely to the assertion that the Lingeses took the business away from DeFilippo to their own advantage?
it was limited solely to that one issue.
And that was not an issue, at least according to your client, that was raised in the motion for summary judgment that was heard below?
Correct. And the verdict form specifically asks, whether the Linges breached their fiduciary duties owed to DeFilippo by taking the business for themselves to the exclusion of DeFilippo, and that's what the jury found. It has nothing to do with putting money in their pockets, taking opportunities, anything like that. It's whether or not they took the business to exclude DeFilippo, and that's what the jury found. So the suggestion that that claim should have been disposed of on summary judgment, there's no argument to that effect. So I would respectfully submit the trial court got it right by denying that, the motion. And as far as, and this is a proper direct claim under Florida law, because under Florida law, for a member of an LLC to state a direct claim for breach of fiduciary duties, they have to establish that there's a direct injury to them, separate from the corporation, or direct harm, and a special injury that's unique compared to any other of the members of the LLCs. And in the answer brief, I've gone over several cases that address this exact same factual scenario, where the majority members vote to dissolve the entities, to sell all the assets to new entities that they've set up for themselves so that they can take over the goodwill, the business, and run with it without interruption. This isn't a unique fact situation. It happens around the United States. There's no Florida case with this specific set of facts, but everywhere else that it happens in the United States, the courts uniformly hold that this is a direct claim for breach of fiduciary duties. And it satisfies Florida's criteria for bringing a direct claim, which is direct injury or direct harm and special injury. As far as direct harm, the cases that I cited in the answer brief that stand for the proposition that this factual scenario is a direct harm that's separate from harm to the company is Hadinger versus Freeman. It's a 2000 Pennsylvania case, and Noax versus Schoenborn, an Oregon case. And as to the second prong, a special injury that's unique to Mr. DeFilippo, not shared by the other members, Boyer versus Wilmington Materials, Inc., a Delaware case, says that this factual scenario creates a special injury to the member. So even under Florida's analysis about what constitutes a direct claim, this falls squarely within that. Again, their argument that they complied with the dissolution statutes and the operating agreement, that's that's a red herring. Other cases address and reject those same arguments, and I recited those cases in my brief. That's Grotto versus Grotto. Even if, you have to do the actions in good faith. You can't just say, I've followed the statute, I've followed the operating agreement, therefore I'm absolved of liability. If you're doing it to exclude a member, then it's not done in good faith. Also, the other case on that point is Boyer versus Wilmington Materials, Inc., the Delaware case. Also rejects the argument that if you comply with the statutes and operating agreements, then you're absolved of liability. So on that basis alone, the fact that they didn't raise in their motion for summary judgment this particular issue and claim that ultimately went to the jury and prevailed, this court should affirm the trial court's denial of their summary judgment motion. As to their position that they should have been granted, their motions to dismiss should have been granted, they simply adopt the same arguments that they made as to the summary.
What if it had been included in the motion and the trial court denied it, and then it goes to the jury and they render a verdict that's contrary to their assertions in the motion, then what?
Even if they raised it in their summary judgment motion, it should still go to the jury because it was, as the court noted, it's a disputed issue of material fact as to whether they did these things to exclude DeFilippo and whether or not that therefore is a breach of their fiduciary duties. Breach of fiduciary duty isn't a claim that's disposed of as a matter of law. It's, and I cited several cases that talk about the breach of fiduciary duty claims are fact-based. So it would still go to the jury, even if he raised it. But he didn't. And any argument about, they try to recast it as a usurpation of corporate opportunity, any argument to that effect is just immaterial because that's not what it is. And as to the motion for summary judgment, it should similarly be denied and affirmed by this court because, again, he didn't raise any argument specific to the claim that ultimately prevailed, which is a direct claim. And the only issues that they briefed as far as arguing whether or not the claim was direct or derivative, they made two sets of arguments. Said first, paying excessive salaries and paying unlawful dividends are derivative claims. That wasn't the issue that went to the jury, and that's not the issue before the court.
Well, wasn't the corporation was dissolved, so how could he bring a derivative claim if the corporation was non-existent at that point?
Right, and that's another reason why a direct claim would be appropriate. And there's a Florida case that talks about that, where the entity was involuntarily dissolved and it couldn't be reinstated, and because of that, the court said in that case, what would have been otherwise a derivative claim was properly brought as a direct claim. And
just one more point or question of clarification. As far as a direct injury, this partnership, there were only 3 partners in this partnership, correct?
Correct.
So it was the 2 Linges and Mr. DeFilippo, correct?
Correct.
Mr. DeFilippo was the only one who was out as far as the business continuing after the original business was dissolved, correct?
Correct.
Okay, and so his claim was it was the value of his stock had gone to 0 because the company was dissolved, correct?
His claim is that not quite in that phrasing, it's more that his personal property, which is his interest in the business, was eliminated. It was taken. He lost it, and it went to their gain.
And he had objected to the dissolution of the company, or the dissolving of the company, correct?
Absolutely. And with that, unless there's any further questions, I would respectfully submit that the trial court's denial of their motions to dismiss, as well as denial of the summary judgment motion, should be affirmed.
Thank you.
Thank you.
Your Honor, regarding the uniqueness of the injury, I would point to the Carton versus Walton case. That was also 3 shareholders, 2 against 1 on the vote. And that court held that those claims brought individually, even though he was the only shareholder affected, were actually damages or claims for the company that should have been brought as a derivative action. They're very similar claims. We briefed that on both initial brief and reply brief, and also below to the lower court. That case, I think, controls that issue. Regarding how he could have brought a derivative claim after the companies were subsequently dissolved. They were not dissolved when he filed his original complaint, but by the time the second amended complaint, after a bunch of motions to dismiss had come through, it had been. But the section 608.4431 subparagraph 2B says that dissolution of limited liability company does not prevent commencement of a proceeding by or against a limited liability company in its name, which is different than case law on corporations in chapter 607 last time I looked. But
Counsel, would you agree that the question of your client's intentions as to why they were dissolving the corporation and why they were taking certain actions is always going to be a question of fact for the jury?
No, I do not. I think there's lots of scenarios where that would not matter at all. In this case, rather, there is no rule in Florida that you have to stay in business with your partner forever, whether it's a corporation or an LLC or a partnership. It's like a marriage. There's no rule in Florida that says you have to remain married forever. You can undo it. The question is, did you go about it properly? My clients did that. They hired the biggest law firm in the county with a corporate law department, paid a lot of money to make sure it was done right. That's all in the record. I can give you cites if you'd like. Although they'd formed those two other companies prior to dissolution, in fact, there was absolutely no business being done or money being made. And also, as undisputed material fact in the summary record, judgment record, that's true. The dissolution, the appellee, plaintiff below, was offered more than his 1/3 share of the liquidation value. My clients really did nothing wrong. You're allowed to dissolve companies in Florida.
When your clients went, or when the Linges went overseas to negotiate with the material supplier, were the parties still in partnership with each other?
Yeah, although I don't think that fact is material to the argument that we're making on appeal or that we made below on that.
They were in partnership together, correct?
Yeah.
Okay, did your clients ever dispute the fact that the key that Mr. DeFilippo had to open up the area where the financials were kept did not work when your clients went overseas?
I don't remember that dispute. I do remember DeFilippo admitting that he came in and took the company's financial records in May of 2008 while my clients were overseas and never did. He admitted he never did return to the business after that.
Well, also part of that was he wasn't able to gain access to that part of the building that contained the financial records due to the fact that the locks had been changed. Did your clients ever dispute that fact?
Yeah, but that's immaterial, Your Honor, because he never made it. There was no request for corporate records. He had that in his complaint, but it was undisputed on summary judgment. We went through that in great detail.
He was a partner in the business. Are you saying that he wasn't entitled to look at the financial records of the corporation at that point?
There is no dispute below, Your Honor, regarding a financial disclosure issue. None.
So would he have been entitled to access to those financial records?
He probably shouldn't have taken...
I'm sorry, can you let me finish, please?
I'm sorry.
When your clients were overseas, would he have been entitled to see those financial records?
Whether they were overseas or not, he would have been. He probably shouldn't have taken them all with him and left the office without them. But yeah, I mean, there's a procedure, chapter 607 and 608 for requesting financial records. There were no, that's not an issue that went to jury trial, but it's also not an issue, so there was not controverted trial. It never went to the trial. But it's also not an issue that there was any genuine dispute as to material fact below. They filed nothing in response to 1.150. He just conceded that. It wasn't their burden to do it. They didn't do it.
You're well over your time.
I'm sorry.
We'll
Oh, I'm over. I'm sorry. Thank you all for your time.
Okay, thank you very much. No arguments on both sides.